You have much work to do after an attorney hires you and before you can form, present, and defend any expert opinion. Rule 703 of the Federal Rules of Evidence spells out 3 classes of data or facts that an expert can consider and on which he can base his opinions. First, anything that you learn or see directly before a trial. Second, anything that you learn or see directly at the trial itself. And third, any other data or facts that you hear about or learn about, as long as they are normally relied on by experts in your particular field. This rule covers all the possibilities. The first part, things you learn or see before the trial, can cover what you read, any discussions you have with people at accident sites, in hospitals, at job sites, or even technical people who wrote software or who ran machinery. It can also include the results of well-defined research that you've done that is relevant to the subject of the case. All these activities generally happen well before the trial. The rest of this lesson focuses on what you may do and how you may collect this evidence and information. Regarding the second part of Rule 703, you will occasionally learn something new at the trial itself. Sometimes other witnesses may introduce evidence that you will see on the witness stand for the very first time. Some states require that you hear such evidence directly, which means that you might have to sit in the trial for hours or days before your own testimony, listening to these others testify. Other states impose the opposite requirement, explicitly disallowing you from being present at the trial when other witnesses testify. The third part of Rule 703 has to do with the basis of an opinion and with facts that are, quote, normally relied on by experts in your particular field, end quote. Some people call information obtained from other people hearsay, while others might call this, quote, getting my assistants or my students to do the work, end quote. In other cases still, you may hire a third party, such as an outside lab or an investigator, to do a specific task. If experts in your field reasonably rely on such people, then you can use information that they gather as part of the basis for your opinions. Let's take a look at some issues paramount to ensuring admissibility of your work. The goal of your eventual testimony is to convince people of your opinions. Your investigations and overall work will help you to do just that. First, you have to collect information about the technical elements of the case. Only after reviewing and studying information, performing any necessary tests, and following necessary methodologies, can you form opinions that you can express in an expert report or in testimony. A key tactic, then, is that what you do will help you technically and professionally come to the best opinions. How you do it will help ensure that your opinions are seen as admissible and that they will be allowed to be heard in court. Remember, you are on a playing field called the law. You have to play by the rules in this game. First, you have to be familiar with the facts in the case and the sequence of any events that happened. And second, you must carefully document any tests that you personally run or oversee, all observations made, and any measurements taken. You should include all results, whether positive or negative, whether good or bad. Third, any demonstrations that you plan to use during testimony have to be substantially the same as the events in the actual case. Fourth, any materials that you use in tests must be the same as were involved in the case. Fifth, you must document all steps followed and methods used. You should be able to use industry literature and publications to show that the chosen tests or methods are recognized as authoritative in your field. Sixth, consider with your attorney whether to use and pay for an independent peer review of your analyses and work. Playing by the rules of this legal game will help to ensure the admissibility of that work. The opinions that you form must rely on solid investigative and preparatory work. But you are not an attorney, so you will not know about all the legal elements of the lawyer's case. You will sometimes have to meet legal standards that vary from jurisdiction to jurisdiction. So you have to choose tests to run in order to acquire the information needed to meet those legal standards. Well, to do that, you have to explicitly ask your attorney about the standards for your particular jurisdiction. For example, Maryland or Rhode Island or California may use different legal tests for insanity. As a psychologist, perhaps, in those states, you would need to know about the differences so that you can pose the right questions and determine the information needed from your investigations or interviews to meet local, state, legal standards. Now, lawyers learn numerous reasons for raising objections to the validity and admissibility of not only you, but your evidence and your opinions. You need to anticipate, as an expert witness, the following possibilities so that you can avoid being tripped up by any of these objections. For example, an attorney can object to the admissibility of your testimony for any of the following reasons. 1. You're not qualified by knowledge, skill, experience, training, or education in the specific scientific field needed for this case. Consequently, then, you should prepare in advance your explanation of why your background does indeed qualify you to offer opinions about the facts in this matter. Next, your opinions might not flow from reliable facts or data. You should prepare in advance to show that the facts were reliable and that your opinions did reasonably flow from them. Next, you did not use reliable methods in your work. You should prepare to cite examples from your field and its literature that show that you did. Another objection they can mount is that you did not run enough tests or collect enough data to justify your conclusions quantitatively. You haven't, perhaps qualitatively, relevant conclusions to present. What you rely on, the opinions you offer, they must be directly relevant to the case. Your opinion may have merit, but if it's not on point, you won't be allowed to waste the court's time. Another objection could simply be that you relied on hearsay for your opinions. You have to ensure that any information you rely on and that you have acquired from third parties is usually relied on by experts in your field.